Hi everyone, today will be the last session so that I will be going through two papers, which is first one, the 20 and 23 main paper, then I will be going through another one is uh 2022. So for the first set, right, now we will go to the compulsory question. Compulsory question is pretty lengthy as usual. So when you see the questions, right, uh, as what I have suggested earlier, you may have to identify the issues by paragraph, not by sentences in each paragraph, so that when you see the keywords there, you will be only able to jot down the issues accordingly, and your answer will be more presentable. So we will start from the first paragraph. A has signed an agreement with TAS to supply the things, and the factory is at Kota Baru, Kelantan. And then for the manufacturing of products, this is the contract, the subject matter, and TAS has the registered address at KL. Okay, so we have the informations of the party. Now, looking at the second paragraph, the purpose of the contract, EAS has appointed an agent, Ahmad, who resides in Kota Baru, Kelantan, to source the materials and the transportation for the supply of the materials to Abu's factory. Now, since Abu does not have an office in KL and he does not deal with anyone from TAS, so he only deal with Ahmad for the purpose of supplying the materials under the contract. Some of the customer found that the pro and now some of the customer found out that the products from Abu were defective and refused to accept the same. So as a result, Abu suffered a loss of profit amounting to this amount. You have to highlight for this kind of keyword like the information of the party, and then like where is the place and what is the subject matter. And now, upon investigation, Abu found that the defect in the product must have been caused by the material supplied by Ahmad. Now, Ahmad denied the liability and claimed that the materials supplied by him are only one of many other materials that are used to manufacture the products for Abu. The formula that is used to manufacture Abu's products is not reduced into writing. Abu disagreed with Ahmad's contention and wishes to commence a legal action to recover the loss that he suffered. So after we read the questions, right, we have to be very, 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 very sure that who are we advising. The reason why I repeat it, very important, is because this is what I feel. Last time, when under the panic, I advised the wrong party. So that I wish this will not happen to any one of you. That's why during the exam time, you have to make sure that you highlight the parties in different colors so that you will be able to identify the correct party that you are going to advise. Since now we are advising Abu whether he has a complete cause of action and who should he sue. Okay, by looking at this question, since it allocates for 7 marks, so we have to discuss for two issues. First one is whether the cause of action is complete. Second one, who should Abu sue? Can I have the thought from you all and you may respond in the group chat. What should be included in the Okay, we come to this come to the answer one by one. So first thing is whether Abu has a complete cause of action. What do you all think that should be included as part of your answer? Okay, I see Kevin's answer is Lim Ken and Chu Kun. This is correct. Okay, so Lim Ken and Chu Kun is correctly applied. So what is the substance in the case? Like what is the decision given by the court? How to fulfill whether or not the cause of action is completed? Okay, Sandeep, your answer is totally correct. In the case of Lim Kian and Chu Kun, the court held that there must be a plaintiff to be sued, defendant to be sued, and then another one is the fact is entitled for the plaintiff to succeed. So that when you're applying to the case, when you are applying this case in your as your part as your answer, you must be able to write it out. So we have sort out the first part, which is the course of action, whether it is complete. Now, the second part is who should Abu sue? I can see the answer is against task. Okay. Anyone have different answer? Okay, Cindy, your answer is totally correct. Because the thing is, I am not sure whether your lecturer has told you before. You can see Ahmad, who is Ahmad? TAS has appointed an agent. So agent is considered as an independent party to a company. That is the reason why when you are suing task, you also has to sue Ahmad, and then let the court to decide whether whether they can be joined together. Because the thing is, now, the company wouldn't simply enter into a contract between you. There must be some people brings the contract and for the other party to enter. That is the for your answer, so that in your answer you must be able to write out that uh Abu is advised to sue past Sandria Berhad and Ahmad as the defendants. Okay? Okay, now we come to the second part. In which court and where should the legal action be commenced? I think this one will be pretty easy and straightforward. Can I have your answer in the chat group? Now, looking at the facts, the contract matter, the subject matter is goods sold and delivered. And then now they are claiming for not less than 1 million or not less than 1 million. So according to your section 69 of your SCA, which is Subordinate Courts Act, unlikely that Sessions Court has the jurisdiction. Okay, so that High Court will be the appropriate court to try the matter. This is the first part. Because when you see in which court, this is first part of your answer. And where, this will be the second part of your answer. When we are going to address, when we are going to write our answer into which court, you must be able to identify the jurisdiction of the court. So by looking at the facts, not less than 1 million ringgit. So obviously, you have to write it out according to Section 69 of your Subordinate Courts Act. Uh, Sessions Court does not have the jurisdiction. Therefore, only High Court will be able to try. Okay, because this is how you gain the mark for the first part. Then the second one, where now we look into the facts. Okay, Thus factory is at Kota Baru, Kelantan. Okay, and then supply contract. Okay, so now we're looking into we now have to go back and we now have to refer to the section 23 of your CJA. When you see the sections 23 of your CJA, what does it say? Uh, cause of fracture arose. Okay. Second one is the place where the defendant has a place of residence or having a place of business. The third one is convenience of the party to try the action. So by looking at the fact, the cause of action is taken place at Kota Baru, Kelantan. And then the defendant, Ahmad, also having their place of business. This one is residing in Kelantan. Task address is also at Kelantan. No, sorry. Task address is at Kuala Lumpur, registered address. That is the reason, so that by putting it in your answer, it will be a bit uh, open-ended because it could be at the High Court of KL or High Court of Kota Baru. Is that okay? Yes, indeed, correct. You can, it is up to the plaintiff because if the plaintiff now says that, oh, uh, Kelantan, maybe my business is at there, but I think that KL also can have the power to try, that has the jurisdiction to try, because according to your Article 121 of your Federal Constitution, the local jurisdiction of the High Court of Malaya is governing the whole West Malaysia. That's why you can either file in Kelantan or in KL because it fulfill the section 23 of your CJA also. Okay, third part, mode of originating process that should be used to commence the legal action. This one is quite easy and straightforward because nothing but just you can write out all the five rule two of your rules of court with action. Because this one, if you're looking at your order 5 rule 2, it says that uh, there must be a substantial dispute as to facts. Now we're looking here. They are disputing whether or not the materials supplied by uh by these people by by Ahmad is defect so that it fulfill the requirement according to Order 5 Rule 2. So this is how are we going to approach the 4 marks question? So usually the 4 marks question is pretty straightforward and you may conclude it within 2 to 3 lines, unless something like this, because in which, called, and where is separated into two, so that this one might be taking you some time to structure your answer. Unlikely to this one, more of originating process. All you need to do is you quote Order 5 Rule 2 and then just do some explanation will be suffice. Is that okay? Okay, now we're coming to B. I assume that this one we have discussed before. Never mind, I will go through it again. So, assuming that Abu has commenced the legal action by way of writ at High Court. During CM, the learned judge gave a direction that any interlocutory application must be made 2 months before the trial. This is the so-called CM direction. On the first day of the trial, counsel for Abu wished to move to the court for an order to amend Abu's statement of claim. The judge refused the request by Abu's counsel on the ground of CM's direction. The learned judge did not believe Abu's testimony and found that his products were manufactured using more than one material. And then the High Court dismissed Abu's claim. So the first part is whether the refusal of request is appealable. I I think that we have covered these two questions, but also I don't mind if you can share your answer with me in the chat group. Okay, I can see the answer. I can see the answer in the chat group. Yes, correct. It is not appealable because it's just a direction. A direction is not a decision. Direction is just like, now I'm asking you to do this and that. It's not something like a written judgment. Therefore, it's not appealable. Because as what we have studied in criminal procedure, in the case of Anggini, there must be a final judgment and the right of the parties has been disposed. There must be, which means that it must be the matter must be finalized. From the fact it's just a direction, therefore it's not appealable. Now, the second part, advise Abu through the relevant procedure and the applicable test to be used to challenge the findings of the court. This one I also have covered in my previous session. So does anyone have your answer? You may post in the chat group. Okay, I can see some answers in the chat group already. Okay, I think everyone can look into Cindy's answer because the core issue is on the relevant procedure and the applicable test to be used to challenge the finding. Therefore, the keyword is relevant procedure and the applicable test, so that your answer should be based on state of execution. Because as a general rule, an appeal does not operate as a stay of execution. Okay? So in your answer to this question, right, the first part is you have to write it out what is a stay of execution. And then in for the subheading, you may give a brief explanation as to what is a stay of execution. And then now on the second subheading, then you can separately write out what are the relevant tests. Serangoon Garden, because it's quoted by the court that parties shall not be deprived by the fruits of litigation, and then the nugatory principle, and then those cases like Dato Sri Ling Leong say, and then what other the Dato Sri Ling Leong say is the nugatory principle, and then the Leong Porshi, what is amounting to the special circumstances test. Then your Tan Sri Dato Vincent Tan's case, because merits in appeal will not be sufficed for the court to grant the stay of execution. So in your second subheading, by listing out the applicable tests, these are the cases that you have to be included. Is that okay? Okay, we come to the second question. Plaintiff filed a rate action against three defendants, namely, first one, government department as first defendant, and two individuals as second and third defendant, respectively. Okay, so now plaintiff served the writ on the first defendant by AR registered post by the to the head office in Putrajaya. AR card was duly acknowledged by the director of the government department, affixed a rubber stamp. On second defendant, AR registered post to residential address, and then the AR card was acknowledged by the private security, who also affixed the company rubber stamp. On the third defendant, solicitor who had acted for the defendant in the previous court proceeding by leaving a copy of the writ at the solicitor's office. Now the question is, advise the plaintiff whether the writ was served properly on all three defendants. If this is what happened in your exam, right? So I would suggest you all to separate your answer into three different subheadings, because this will be easier for you to write out the answer and also easier for the marker to mark your answers lah. So we come one by one. Okay. First defendant is a government department, so that how the manner of serving the writ is by AR registered post to the head office in Putrajaya. So we have to, okay, so we have to check the relevant order will be order 73. So if we look at order 73, rule 3, right? So because this one is the what government department. So you may look into Order 73, Rule 3, Sub 2A. It must be served to the Attorney General or other officer designated in that behalf. So if we can see, Attorney General is totally different from a director. So that based on the fact it was not served to the director, therefore Order 73, Rule 3, Sub 2A is not complied. Therefore, the service of writ to the first defendant is bad. Is that okay? Okay, now we come to the second part. On the second part, because it's served to the individual, so service to the individual is only one rule. It's only one order, Order 10 Rule 1. Order 10 Rule 1, what does it say? It must be prepaid AR registered post or personal service. So from the fact it is AR registered, yes, it's correct, but the AR was signed by the private security guard in the condominium. So it's also deemed as invalid. Okay? Now, the third one is to the defendant solicitor. So Order 10 Rule 1 Sub 2 says the solicitor can accept on behalf if it is uh it was endorsed in the rate that there will be accept the service of rate. But the question here is the solicitor acted for the third defendant in the previous court proceeding. This is a very tricky part because as of now, we are not sure whether the solicitor has discharged themselves as the third defendant solicitor in the current proceeding. That is the reason why we have to we might have to use this magic word lah. Assumingly, assumingly, the third defendant solicitor is not acting for the third defendants in for the existing action, the service of writ to the third defendant is invalid and bad. So that when you see there are multiple parties, right, you just need to structure your answer by using the subheading. It will be better for you to write your answer for yourself. So this is what I suggest to everyone. Because 9 marks only, I don't think so. There are quite a lot of things to write. Because everything you just need to copy the relevant order and rules. Then you just need to put your conclusion whether the service is valid or bad. Is that okay? Now we come to part D. The plaintiff filed a rate action against two defendants for damages. Okay, Cindy, I saw your question already. Uh, Not necessarily, because because the fact here is very a bit like in the sense of confusing the candidates lah. I am the one who was confused and trapped lah, because I was also having the same thought whether the third defendant has to use a new solicitor. Sometimes it is not necessary unless there are certain issues like, let's say right now I am the one suing the third defendant, and the solicitor of the third defendant has previously advised in acted for me. That's why This is what we have studied, conflict of interest. That's why, and then third defendant will have to appoint a new solicitor. Okay, but in anyhow, in this case and in this question, they didn't mention for this kind of facts, so that we can only use the word assumingly. That is the reason why I use this word, because assumingly, I am not giving you a very definite answer. I'm just giving you based on my assumption. Is that okay? Okay, we continue on the part B. The plaintiff served the writ action against two defendants arising from a breach of contract. So after 3 months, the plaintiff obtained the leave from the court to include Chong as the third defendant in the suit and served the writ of summons. Chong is unhappy that he is unnecessarily made the defendant to the suit and has sought your advice as to the procedure he should adopt to remove himself as a defendant. So, can I have your answer in the group chat? Okay, I see the answer here. Okay, very good. You all managed to answer the question already. Actually, everything is based on Order 15 and Rule 6, because from the fact here, it is very obvious that this is a misjoinder of party, because from the fact that Chong is unhappy that he is unnecessarily made a defendant to the suit. So to differentiate what is non-joinder and misjoinder, in non-joinder, it means then there is a party who is supposedly to be joined into the suit, but maybe out of a mistake, he or she was not included as a party in the action. This is the non-joinder. Whereas in the misjoinder, this is what happened to Chong, because he was innocently became the party in the suit. That is the reason why we have to make sure what the law we apply is correctly. So that based on this situation, it is very clear that this is a misjoinder of party in the action. So that you need to copy whatever Order 15 Rule 6, Sub 1, Sub 2, Sub 3, everything out. Is that okay? Okay, now we come to C. Farah entered into S&P to acquire a double-story dwelling house from D, and he had paid a deposit. At the same time, D commenced negotiation with Wong to purchase Wong's house in the neighboring housing estate. However, Wong changed his mind to sell the property to D, and then D, unable to proceed with the purchase of Wong's property. D then informed Param that he does not intend to proceed with the sale of purchase to Param and offer to refund the deposit and pay some compensation to P. Now, P has refused this offer and demanded that the sale and purchase agreement must be completed. Advised Param on the quickest mode of obtaining judgment against D in order to compel D to proceed with the sale of the property to P. Okay, since it is 9 marks question, you may share your answer in the group chat so that everyone can learn like how are we going to answer this kind of question. Okay, I can see most of the answers are concerning on Order 81, Rule 2, Order 81 of your rules of court. Yes, it is part of your answer only. It might be part of your answer only. Because since it is allocated for 9 marks, what I suggest is, first thing, we have to separate into three different parts. The first thing is, the reason why I say so, because now, refused to Dewan's offer, and then now he demanded to to compel uh to compel Dewan to proceed with the sale of the property. So the quickest mode, yes, it is correct that Order 81 is the correct order and applicable one. But to me, right, I will be separate my answers into three different parts. First one, how are we going to this first? How are we going to the Order 81 first? The first thing is we must initiate or commence a writ action from by Param against Dewan. So the first one, your introduction will be the appropriate mode to commence the action. This is what the order is Order 5, Rule 2, because you have to tell the examiner that, yes, you never tell me, but now I'm going to tell you what I know. So your Order 5, Rule 2 is the introduction. It has to be a writ action because there is a substantial dispute as to the facts. Now, when you come to the writ action, um, because the mode is on the summary judgment, you have to tell to the examiner as well. After you serve the writ from Param to Dewan, Dewan is given 14 days to enter into an appearance. This is given in your Order 12 Rule 4. So that after you write out this in a general and briefly, then you may only proceed to write out your Order 81. Is that okay? Because you have to tell the examiner, or you are not simply giving the answer on Order 81 only. You also have to tell to the examiner how do you substantiate your answer? How do you substantiate your Order 81? You must tell them at least some background on why you have to put this. You just give some explanation or some reasoning behind your before you go to your Order 81. Is that okay? This is the logic why they're allocated for 9 marks. If simply based on even for the order 14A, you also have to do the same. If it is given 9 marks now, I mean, because in 9 marks, as what I said last time, Since it's considered as a very high mark, that is the reason why you have to include some of your answer and include some of the additional points for you to secure your marks. Purely relying on the order 81 may not be suffice lah. Okay, then we move to the third one. A filed a writ action against four defendants and the writ was issued on this day, 1st February. By 20th of July, P managed to serve the writ on first, second, and third defendant. The fourth defendant is evading the service. On the case management date on 20th of July, the court directed that if the writ was not served on the fourth defendant by next CM date, which is on 30th August 2023, the court will strike out the writ against the fourth defendant. So now the issue is advise the plaintiff on the procedure that he should adopt to ensure that the writ is validly and effectively served on the fourth defendant before the next CM date. Now, you may share your answer in the group chat. Okay, I see the answers from the group chat already. So, yes, Sandeep, you have answered it correctly already. And then Cindy also. Uh, then goes to Jeannie because the first thing is you see the keyword here, validly and effectively served on the fourth defendant, which means that the 10 marks is divided into two parts. First one, you have to make sure whether the writ is valid because you see from the fact the writ was issued on 1st of February. Now, by this date, 20th of July, which means that according to your Order 6, Rule 7, your writ is valid for 6 months only. Now, it's very close to the expiry date already. That is the reason why you have to use Order 6, Rule 7, Sub 2 to renew the writ first. And the mode of application is by an ex parte notice of application supported by affidavit. Once the writ is renewed, then you can only proceed to apply for your substituted service. Okay? The case for renewal of writ is the case of S. Shelby. I will type in the group chat. This is the case that you have to include it for your answer to renew the writ. This is the case. And then after that, you have to, how are you going to effect your substituted service? You have to follow the practice note and then read the mala because in the case there are certain elements that the defendant must be invading the service of writ. So it's very clear from the facts that the fourth defendant is evading the service. Therefore, your ground to apply for the substituted service is sustainable. Is that okay? Then you can go for your Order 62 Rule 5 on how to effect the substituted service. Is that okay? Okay. Then we'll come to the part B. James filed the writ action against Peter in the claim for goods sold and delivered. At the trial, James' claim was dismissed by the court on the ground that he had failed to tender the exhibit as the relevant invoice and delivery orders. James did not file an appeal against dismissal. Instead, he has filed a fresh action against Peter for the same subject matter and intends that at the fresh trial, he will tender the invoices and the DO as exhibits in the hope he would success in his claim in the second time. So now Peter sought your advice on how he should dispose of James' second claim in the quickest way possible. I guess this one is quite easy. If you have attended my classes. Correct. It's Order 18 Rule 19. Striking off uh striking off the pleadings because uh what includes in Order 18 Rule 19 is no reasonable cause of action, scandalous, frivolous, vexatious claim, and then abuse the process of court. So we're looking into the fact, instead of going for appeal, he is filing a fresh claim. So what happened is, because the matter has been finalized and also dismissed by the court, this is a so-called res judicata. The matter has been adjudicated. So if you are filing a fresh claim on the same matter, this will be caught by the rules of res judicata, and your course of action will not it's not sustainable. This is given in the case of Sim Kie Chun. So how are you going to answer this question is that you have to firstly you have to write out striking of pleadings, because the first thing is all you have to explain what are the elements in Order 18 and Rule 19. When you have listed out the criteria, then you can make your conclusion. Your conclusion is based on the fact that the matter has been adjudicated by the court in the previous proceeding, and instead of appeal, James has filed an action for the same matter again. This is what explained in the case of Sim Kie Chun. Therefore, he has no reasonable cause of action, and Peter may strike out the pleadings filed by James. Now, we come to how to apply to strike out Order 32 Rule 1. Notice of application in Form 57, supported by affidavit. That is the end of your answer. Is that okay? Now we come to C. Plaintiff obtained monetary judgment against a defendant. Defendant is a substantial shareholder in the private limited company involved in the transport business. The plaintiff wants to enforce the judgment against the defendant. Advise the plaintiff on the mode of execution proceedings that he should adopt. Any idea? Okay, Order 50 is correct, charging order, because charging order is you want to attach the shareholding of or the security or bonds in against the defendant in the company or the stock market. So Order 50 is correct. But to me, right, the time I think I have answered this question as well. So that the time, just a brief explanation on the limitation. Because according to Section 6 of your Limitation Act, right, the plaintiff is given 12 years to enforce the judgment. To enforce the judge, the limitation period to enforce a judgment is 12 years. So that you may put a lead, few lines now just to tell the examiner that, oh, you know, there is a limitation period for the plaintiff to enforce the judgment. So after the the brief explanation, then you can go to your Order 50, rule 1, 2, 3, 4. Is that okay? So Kevin, I can see your answer is on garnishee proceeding. Garnishee proceeding is basically you are going to, is for the plaintiff to attach the money from a third party who is the garnishee. That means now I let's say I am the plaintiff, and then uh A is the defendant. When I'm going to enforce the judgment against A to claim the money, I found out that A O B is owing A certain sum of money. Instead of claiming the full amount from A, now I'm going to claim the money from B. So that this is a so-called garnishee proceeding, which means that the plaintiff is attaching the money from a third party. Is that okay? Okay, now we come to number 4. GTA is the association registered under Societies Act. Objective is to promote the trade interests of its members and to enhance the relationship among the members. Hassan is one of the member. Dispute arose between Hassan and the committee member in respect of his conduct regarding the affairs of the association. The committee members of the association decided to call for an EGM for member to discuss and pass a resolution to expel Hassan as a member of the association. Agenda of the EGM includes a discussion about Hassan's impugn conduct. Fearing that the defamatory remarks may be made against him during the discussion at an EGM, Hassan, 7 days before the EGM, through a lawyer, filed a reaction at the High Court against the association in the name of the president, seeking declaration that association does not have the power to expel him based on the ground of his impugn conduct. At the same time, filed an ex parte application applying for an order to restrain the convening and holding of the EGM, pending the disposal of his writ action. This is the ex parte application. Hassan's lawyer did not give notice of the ex parte application to the president of the association. Neither did Hassan state in his affidavit in support of the ex parte application why the ex parte application cannot be heard inter parte, and why no notice was given to the president of the association. Given your opinion as to the propriety of the ex parte application filed by Hassan, in your answer, discuss the appropriate procedure and the legal principle in relation to the ex parte application for interim injunction. So, what are your answers? Here I can see the answer already. Order 29. Yes, because the whole purpose is the legal principle in relation to an ex parte application for an interim injunction, so that your answer should purely based on the application for injunction. So if you have read the questions right, actually the part A and part B is quite repetitive, because the thing is they are using 25 marks to ask you the whole subject matter on the injunction. That is the reason why last year I have skipped this question now, because as what I have said, please avoid those full marks question or more than 15 marks. Because okay, but anyhow, we can still go for it, because now it's a trial run. Yeah. So because the the question is concerning on the procedure and legal principle. So that what you have to include is what is an ex parte application. Your order 29 1 sub 2A has to be included. And also, if possible, please explain the case of American Cyanamide, because ex parte application can be used in various one, just like your marijuana injunction, your Anthem pillar, you have to tell to the court on which particular ex parte injunction you are applying. So, as we know that the easiest one, the threshold is the lowest one is the prohibitory injunction. The prohibitory injunction, you just use the American Cyanamide, you'll be fulf- you will be sufficed now, because the criteria are serious question to be tried, full and frank, balance of inconvenience. Whereas Mareva is using good arguable case. Anthem Pillar is using prima facie case. So that from the by you by from the wordings, right? Anthem Pillar is the highest one, which means that you must be able to show that your case is strong and solid, because you can establish your case in the first place. Otherwise, your anthem pillar order for the first round is disqualified. Okay? So after you explain the case of American Dynamite and what is the ex parte injunction, then you can go for the procedures. Is that okay? Okay, now we come to part B. Assuming High Court does not hear Hassan's application, applying for an order to restrain the convening and holding of the EGM pending the disposal of its writ action by way of ex parte, but set the matter down for inter parte hearing 2 days before the EGM, after parties have exhausted their exchange of affidavits. As the lawyer for the association, outline your submission to oppose the inter partes application by considering the relevant legal principle and decided cases. 18 marks. So you may post in the group chat on what should be included in your answer in order for you to secure these 18 marks. Okay, by answering this question right, given that it is an 18 marks question, so you have to write out whatever included in your first part. So your general principle, like American Dynamite, Order 29, Rule 1, Sub 2A, and explaining the timeline, perhaps it's okay because you have to outline your submission to oppose ma, so that what includes in your has to be included in your answer is rule 1 2BA. No, sorry, not rule 1 2BA, it's rule 1 2A, the full and frank disclosure. Because the first part is, as you can see, Hassan does not explain as to why he has not, you see, from here, neither did Hassan state in his affidavit in support of the ex parte why the ex parte cannot be heard inter parte and why no notice was given to the president of the association. That is the reason why you may Hassan did not comply with Order 29 Rule 12A. Okay, this is first. This is your first objection. The second objection, okay, I guess Jeannie answered it correctly already. Order 29 Rule 12C, which says that an injunction cannot be used to stop a meeting. And this is what you have to include in your answer. This is the second objection for you to oppose the injunction. Is everyone okay? Okay, 5A, parties again. Okay, so we're looking into the question. Ahmad, the managing partner of ABC Trading Company, a partnership, sought your advice to file a rate action against two parties, Bukit Rusa Club, Registered Society, and Estate of Kumar, the deceased. No letters of administration or probate has been issued for the estate of the deceased. So now, advise Ahmad who should be named the proper parties in the proposed writ of summons. You may write your answer here. Okay, I can see the answers here already. Okay, so that in your answer you have to separate it out. First one, who will be the plaintiff? ABC Trading Company, who is a partnership in the capacity. So according to your Order 77 Rule 1, the name of the partnership can be named as the plaintiff. Therefore, ABC Trading Company will be the plaintiff in the action. Now, the problem arises on the defendants. First one, Bukit Rusa Club, a registered society. So that pursuant to your section 9C, section 9C of your Societies Act, the public office, the name of the registrar has to be the defendant. If there is no registrar appointed, then you can go for the office bearer like chairman, secretary, and anyone holding the position. The most headache part is again the third defendant who who is the person the uh holding the estate of Kumar, a deceased, and no letter of administration or probate have been issued. So in this case, right, you have to include the case of Ang Hoi Yin. In this case, the court held that the personal representative can only be sued if the letter of administration has been granted. Is that okay? Yes, Cindy, he can sue in the capacity as a partner. But just that when you are using the company to sue, it's easier lah because when you are using because for the ease of addressing the parties lah, unless you want to protect your company until this level, you're just using your personal capacity to sue, but anyhow you cannot escape what because you are suing them as a partner of this company, right? Yeah, so better that you use the name of the partnership to sue unless unless the fact is unless the fact is different. Like Ahmad, who is the sole proprietor of ABC Trading Company, then your order will be different and the name in the action will be different as well. If a sole proprietorship, then you have to rely on 79 now. Like you are addressing yourself, Ahmad, in bracket, trading as ABC Trading Company. Because as a sole proprietorship, this is how are you citing how are you going to cite the parties in the action? Okay? Okay. Yes, this is how sole proprietorship to be named as a party lah. Okay. Now, Pang filed the writ action against Donald in the High Court. Cause of action is defamation. In the statement of claim, Pang quantified general damages and prayed for a sum of 2 million as general damages against Donald. After pleadings were closed, case was set down for trial. On the trial date, Donald and his counsel were absent because of serious flooding. As telecommunication services were disrupted, Donald's counsel was unable to inform the court of his difficulty to reach the court. As Donald and his counsel were absent, the court gave judgment for Pang in the sum of 2 million ringgit without Pang having to prove the damages and also granted cost for 50,000 to Pang. Advised Donald on the validity of judgment entered against him and the procedure he should adopt and legal principles involved in setting aside of the judgment. Okay, you may share your answer in the group. Okay, I can see the answer is here already. Now, looking into the fact on the trial day, your answer should be focusing on Order 35, Rule 1. In the absence of the party, the court may enter into the judgment. So the court is correctly to do so. And your Order 35, Rule 1 sub 2 says that this is allowed. And then going on to your Order 35, Rule 2, the aggrieved party may file to reinstate the proceeding within 14 days so that Donald has to rely on 35 Rule 2 to reinstate the action within the 14 days by giving a good reason. So whether or not it's a good reason, we have to look into the fact already. In the statement of claim, Pang quantified and prayed for the sum of 2 million as general damages. So according to your Order 18, Rule 1 sub 2, uh, the general damages should not be quantified. Okay? And I guess this is what we also have studied in our general paper when dealing with the statement of claim. Your special damages has to be quantified, but your general damages you will never quantify. This is your strong and the good reason to oppose the judgment. But bear in mind, this is not a JIDA because they enter into appearance already. This is just a judgment based on none of the party appear in the court appear present during the trial. So it is not a JIDA lah. Okay. So your JIDA simply means that, okay, what is the difference between the judgment given under Order 35 and your JIDA? JIDA is when I serve you a writ, you are given 14 days based on under Order 12 Rule 4. So that your 14 days, if you fail to file a memorandum of appearance, then I can proceed to file memorandum of non-appearance against you, and I can enter into the judgment in default based on my statement of claim. This is the JIDA. But in Order 35 is the matter has been set down for a trial and the party has failed to appear in before the court. So the judgment given under Order 35 is a different thing. Is that okay? Okay, we will move to part C. A plaintiff application to amend the statement of claim in the High Court was heard and dismissed by the registrar. And now the plaintiff is aggrieved by the decision. Advise the plaintiff on the next course of action that he should adopt. 6 marks question. I guess it's just purely copy the order only. So does anyone know which order? Correct. Order 56. That is your answer. So you need to copy Rule 1, Rule 1 sub 2. That's all. Whatever relevant, just copy into it. Okay. 6A. Plaintiff filed a writ action against 3 defendants. After pleadings were closed, each of the defendants filed application to amend their defenses, which means amendment of pleadings. So, for the first defendant, wants to add allegation into defense as the plaintiff is gambler, swindler, criminal, allegation. However, these allegations are not connected to the facts surrounding the breach of contract. Secondly, the second defendant in the original defense admitted that he entered into a contract but denied that he breached the contract. In the proposed amended defense, denies never ever knowing the plaintiff or that he entered into the contract with the plaintiff. Third defendant wants to amend the defense by alleging fraud and breach of trust against the defendant but has failed to give particular of the allegations, advise the plaintiff whether he can successfully object to the applications of amendment by all the defendants. So since you see it's separately, so it's better that you can you can outline your answer separately lah. Okay, we will come to it accordingly. So for the first defendant, do you think possible? Okay, tak boleh. Any case to support? Yes, Yamaha Motor, bona fide, no prejudice, and then you also have to consider what the character of the suit will not be changed. So basically you see you want to amend the pleading by adding this kind of nonsense obviously this is not a bona fide application already. So using the case of Yamaha Motor and your conclusion will be enough. Second one, possible is that possible to object? Okay, I can see not possible. Is there any case to support? No, not Yamaha Motor. Yes, Kyoan Maru, because you are going to withdraw an admission consciously made. Now you see the keyword is he wants to deny ever knowing the plaintiff or enter into a contract with the plaintiff. But in the first place, he has admitted that he entered into the contract so that he is withdrawing his admission. Okay. Now, third one wants to amend the defense. Is that possible to object? I can see different answers here. One saying yes, one saying will not be allowed. Before I'm going to give you the final answer, can you all explain why you will say allow or disallow? Okay. Okay, I guess most of y'all was being trapped by the question. Looking into the question again now, breach of contract. And now you want to amend the defense by alleging fraud and breach of trust. Totally different things. So that I don't think so it is allowed lah, to be honest. Because fraud and breach of trust could be a criminal offense, or to be very honest, I don't think so there is any connection. So that when I attempting this question, my answer was no. Because you see, the matter is for breach of contract. But when you raise the allegation of breach of trust, will be different things already. And some more, if you don't know what is if you don't know how to address it, but you die want to use, cannot, maybe you can rely on this ground. Fail to give particulars of the allegations because you did not because the thing is you cannot show that what supports you to amend your pleading. Is that okay? But the main point is fraud and breach of trust are totally different matter lah. And I don't think so it arises in the same transaction as well lah. So that was my answer on last year when I was attempting this paper. Is that okay? Okay, now B. XYZ recently purchased oil palm plantation at the public in a public auction and discovered a place of worship erected on the land in 1950 with the consent of a previous owner. Okay, the place of worship has two occupants and no rent is paid. Then there are also planned 20 houses erected on the land with 50 occupants who are not paying rent and they are not anyway connected to the previous owners of the land. Now the XYZ sought your advice to evict the occupants of the worship and as well as the 50 occupants of the 20 houses from the land. What are the procedures? For anyone? Order 89 only. Then will not suffice for you to get the full, will not suffice you to get even half of the what? Half of the 11 marks. I think you all might have forgotten about order 14. Because you see, squatters, right? Order 89 is correct. Because the squatter is referred to the 50 occupants who are not paying the rent and not connected to the previous owners. But there are two occupants. There are two occupants who has the con who has the who has the consent of a previous owner, just that no rent is paid. Okay, the so that means this one it consists of two different parts. One is concerning on the summary judgment under 14, and another one is on the order 89. Very obviously, the 50 occupants are the 89 one falls under order 89. However, are the these two are the order 14. Is that okay? Any questions? Okay, if no question, then I will go for part C. Arman filed a writ action in Sessions Court against Bakar. Sessions Court granted the judgment in favor of Arman. Bakar filed notice of appeal, and then he wants to adduce fresh evidence at the hearing of appeal in the High Court. Now, advise Bakar on the law and the procedure in respect of introducing fresh evidence at the appeal stage. This one I think I have covered in my previous section. Can anyone recall my memory? Yes, Let and Marshall is correct. And you also have to include your answer, Order 55, Rule 7, because you are appealed to the High Court. Okay? Now we come to 7A. Pam and her 10-year-old son Andy walking along a pavement, and the car driven and above the speed limit by Roger skidded and collided into them. Pam suffered permanent brain injuries, forever unable to care for herself. Andy suffered serious injuries, but made a full recovery. Tony, who is the husband of Pam and father of Andy, sought their advice to commence legal proceedings against Roger for negligence. Advise Tony as to who should be named as the plaintiff in the legal action and the procedure to be adopted. 8 marks. Yes, order 76 is the correct order, but because it is allocated for 8 marks, you have to firstly explain the parties accordingly. Pam, who is Pam? Pam is disability is since on the fact that she suffered a permanent brain injuries, she falls under the definition of a disabilities under Order 76. And Andy is a minor, so that he also falls under Order 76. After you introduce both Pam and Andy, then you can only describe what should be done. in Order 76. Under Order 76, Rule 2, it has to be sued by a litigation representative. And also, a solicitor has to be appointed in order to defend. Okay? This is how are you going to this is how are you going to address the 8 marks question. First thing is you have to explain the parties, not explain like describe the parties, and then you go on your answers lah. Now we come to B. A writ action filed in the Sessions Court against Roger for the injuries caused to Pam and Andy. Now the insurers of Rogers are defending the writ action on his behalf. Trial date is fixed at the end of 2024. Now Tony finding difficult to meet the expenses of taking care of Pam, who requires full-time nursing care. Advise Tony on the procedure should adopt to obtain financial assistance prior to the trial. Keyword is here. Difficult to meet the expenses of taking care. Now, the second keyword is in order to obtain financial assistance. So, which one are we talking about? Yes, interim payment. Yes, and then you use the case, David Chalaya. Because after you explain the procedures, right, you can use the David Chalaya because in David Chalaya, the court has granted twice for the interim payment. Then we can go to the part C already. Prior to the trial date, Roger, through the insurers, made an offer to settle to Tony pursuant to relevant provision. Amount offered is not substantial. Advise Tony on the procedure that he should adopt if he wants to either accept or reject the offer to settle. So your answer here, you have to separate it out because the question is asking you how to accept or how to reject. So that in your answer here, right, you have to make it very smart. You have to put in 2 different subheadings. First one is on how to accept. This is given the under the Order 22B Rule 3. Then you can only go on the other side, like how can Tony reject the offer? Is that okay? Okay, if that is the case, we can go to 2022 already. Does anyone needs a break, like 5 or 10 minutes? Can we, I think we can take a 5 minutes of the comfort break. So after this, I will be speeding a bit on this question, on this paper lah. So now is 17. So I will see you all in 10:25. Is that okay? Okay, then we can take a break from now. I will see you all in 10:25. Anyhow, if you have any question, you can leave your comment in the group chat. Then I will answer to you all accordingly. See you all later. Okay, sorry. Okay, now we come to this 2022 compulsory question. So I will be speeding up a bit. Advise Bintang Bank on the following. So the first thing is, when does the course of action of the recovery of outstanding sum accrue? So you see, the timeline is very, very important. In September, I will for the ease of everyone's lah, I will write the timeline in the chat group. Okay. So looking into the so looking into the what? So looking into the timeline, right? The first demand letter was sent on the October of 2014. But in 2015 December, the what AST sorry yeah, AST sent on the December 2015, Bintang Bank agreed the repayment proposal of the longer repayment. And now the main course of action is on 20th of January. So that this 5 marks question is not that easy to answer. Because when you see the timelines, right, actually it's supposed to be on September 2014 because this is the date where AST and core has defaulted in the repayment. However, they proposed a longer term of repayment, and it took a very long time for Bintang Bank to agree, so that this is what we call the fresh accrual of action. And now, after the re after on the January of 2017, they started defaulting the repayment again, so that the main course of action accrued on 2017. So when we come to this question, right, we have to explain a little bit on the timeline and also have to discuss about the fresh accrual of action. Okay? So anyone does anyone not clear about how do I address this answer? How do my question comes about? Or don't know why I put January of 2017 be the day of course of action accrued. Okay, okay, let me explain again now. In September 2014, this is the first day that AST has defaulted. So supposedly this will be the date. But however, because they they issue a letter to propose a long term of repayment on this particular date, 1 month after the proposal only, and Bintang Bank accepted it 1 year later. That means fresh accrual already. They started they agreed on this date lah. So that means the 2014 does not valid already. It's not valid at all. Now, after they have agreed, with the longer term of repayment, now AST and core again defaulted in the repayment on this date, 20th of January 2017. So this will be the final date of accrual of the course of action. Danny, do I answer to your question?
Yes, correct, sir. Thank you. Sorry. Thank you.
Okay. So the reason why I may spend a little bit longer time on this question is because I found out that this is a bit tougher lah. This paper is a bit tougher, and I guess this one should be the supplementary paper for 20 and 21. However, at the time they want to align the date to the normal timeline, so that in 2021 you do not see any supplementary paper, but 2022 main paper instead. So that is the reason why when you see the supplementary paper, when you see the 2022 paper, it's quite tough. Okay. Now, second part, Who should be appropriate name as defendant or defendants in the legal action? 4 marks question. Who is AST? A partnership, right? AST actually is formed by Ahmad Singh and Thiru. So that according to your Order 77, you can either name the particular partner or you sue the company under Order 77 Rule 1. But of course, for us to serve the documents easier, we will go against the company so that you can copy Order 77 Rule 1 by saying that, or you can either sue the individual partners or the name of the firm. Okay, it's either way. Now the third part, where should the intended legal action to be filed and in which court by what mode of proceeding? So that looking into this question, right, three things you have to discuss. Legal action to be filed. Second thing is which court. Third one, what is the mode of proceeding? Three things are. Okay, we come to the question one by one. Intended legal action. Undeniably, Order 5 Rule 2. Substantial dispute as to the facts. Okay? Second thing, which court? Now, you may share your answer in the group chat. Okay, answer is correct already. But uh, you have to explain a little bit lah. Because the first thing is your legal action to be commenced, right? Okay, High Court at Kuantan, I am so sorry, because I'm a KL people, so that I am not very familiar with whether or not Kuantan has a high court. So to me, right, I will put some wordings there, high court in the state of Pahang. Yeah, because this will be you at least you will not jeopardize yourself as to uh whether or not Kuantan has a high court. Okay, so to me, right, your answer has to be separated into these different parts. First thing, your legal action to be commenced. Mode is Order 5 Rule 2. Why? Because now there is a substantial dispute as to the facts. Second thing, which court? Before you giving the particular court, right, you have to tell the examiner that, oh, what is the subject matter? Uh, this is the subject matter of monetary claim. Monetary claim, you see, 1.5 million plus accruing interest. So that person to your section 69 of your SCA, only High Court can try the matter. And where to file which court to be is more appropriate under section 23 of your Courts of Judicature Act 1964, you have to satisfy the following criteria. First thing, cause of action arose. Second thing, the defendant has a place of resides or has a place of business. Third thing, the cause of matter arose the fact is concerning lah. So that by fulfilling these three requirements, the High Court at the Pahang, in the state of Pahang, will have the jurisdiction. Because the first thing is, firstly, I am not sure whether this place, Kuantan, has a High Court. Yeah, that's why I would rather write into the High Court in the state of Pahang. So if you are very familiar with the High Court location, of course, you can put Kuantan High Court, or you may correct me that whether or not Kuantan has a High Court in the group chat as well. If there's no question, then I will go to B. Based on the same facts, above that, the outstanding sum is 7,500 and no interest accruing. Bintang Bank filed a legal action for recovery of the outstanding sum and was dismissed by the magistrate courts after the trial on the ground that Bintang Bank is out of time to sue. So whether uh whether Bintang Bank can appeal against the magistrate court's decision and support your answer with the reason. Any answer? Okay, no answer. Answer is no. Reason, according to your section 28 of your Cost of Judicature Act, no appeal if the subject matter is less than 10,000, unless it's for the question of law or maintenance of wife and children. Okay? Now we come to question number 2. Well, this one, okay lah. This one, obviously, I think I have discussed in my previous session already. Action commenced by OS. Both plaintiff and defendant filed the affidavit. Once the case fixed for hearing, defendant filed issue a notice to plaintiff that stating he intends to object admissibility on the affidavit for the following grounds. Affidavit filed earlier than the originating summons. Okay, that is a case allowed to do so. Can anyone tell me the case? Ban Lee Bank says cannot. So that if you want to over as now, so now you are advising the plaintiff to overcome the objection raised by the defendant. In the case of Ban Lee Bank, the court held that it is not allowed. So on the other hand, Hong Kong Bank says allowed. So you have to rely on the position in the case of Hong Kong Bank to overcome the objection. Second part of the question, plaintiff only state his business address, not his residential address. How are we going to object? Whether the plaintiff can overcome the objection? Yes, correct. You have to state your place of address and also your business address. Place of residential, sorry. Okay, third one. So that unlikely, the plaintiff can overcome the objection. Third one, affidavit affirmed in Hong Kong, found in English language without a translation in the national language. How to overcome it? Yes, it's rules of court, Order 41, Rule 13, for the Order 41, Rule 13, the language, unless it's directed by the court. Otherwise, the language will not be an issue. Okay? Easy peasy, right? For the this is how the affidavit questions typical looks like. They're only challenging on the contents, but this one will be a bit tougher because it involves the filing date. So that most of the time when you see the affidavit questions will be concerning on the contents like whether the signing was done by commissioner of oath or by the solicitor in the office. Then the second question will be asking you, or the contents contains certain irrelevant allegations without any proof or evidence. Then the third type of the question will be asking you like the language barrier. So when you see the affidavit questions, right, don't be panicked. Just flick to Order 41. It explains your answer, and the answer is very straightforward and there already. Now we come to part B. Advise Rahman on the procedure and the relevant principle of law to prevent Alan from transferring out the land pending trial of the writ action. So without looking into the facts, the keyword is here already. Prevent Alan from transferring out the land pending trial of the writ action. So does anyone manage to identify what is the question asking about? Why suddenly I will see a specific relief act? Yes, it's an injunction, but not necessarily to be an injunction. We go to the question first. Two sisters, Anne and Sally, live and work in Australia, decided to purchase the land in Port Dickson. They decided the title of the land registered in the name of their nephew Alan. Trust deed executed between two sisters and Alan declare Alan will hold the land on trust. Unknown to the sisters, Alan entered into a S&P with Rahman to sell the land and below market value. No mention made in the agreement holding as a trustee. After receiving the deposit and went into hiding. Year later, Rahman filed a writ action against Alan seeking for specific performance and or for damages in lieu of specific performance. Pending the action, Rahman wants to prevent Alan from transferring land. So, Cindy, to respond to your questions, right? Private caveat, I don't think so it's relevant to this topic lah. But injunction will be enough because uh You see, 6 marks only. So all you need to do is briefly discuss the injunction and what type of injunction, but not Mareva injunction, because Mareva injunction involves the usually it involves the cash lah. So that you want to freeze the bank account or the assets of the defendant ma. But now you are just prevent him to transfer the money, to transfer the land only. And pending, and also pending the what? Pending the trial. So normal injunction will do. You need to, so that in your answer, you need to include prohibitory injunction, American Cyanamide, and then the principles outlined in in the case of American Cyanamide. Then your procedure, Order 29, enough. Rule 2 sub 1, 2A, 2BA, Gautim. Is that okay? Airing fault, Airing fault is a stay, it's a stay order, not applicable in this situation. Now part 2. Sally and Anne wants to be included in the proceeding and state the principle the court adopts when considering the application. So this one, quite interesting. Anybody? Okay. I can see A's answer is correct already. So is there any case law? Hong Leong Finance and Stack Hong. What is it about? Maybe I haven't studied this case. Program mining is the correct one because you have to make sure that you are having a legal interest, not commercial interest. Program mining is correctly already, but I am not sure about Hong Leong Finance case. Yeah, so that your answer should include program mining's case, Order 15 Rule 6. And also mother of the rules of court, Order 32 Rule 1, notice of application supported by affidavit. Okay, then we can come to third part already. Third question already. Developer commence writ action again at the High Court against JMB of tower developed by the developer for trespassing onto part of the tower. Developer claimed that disputed area privately owned by developer by virtue of a strata title and is not a common property. JMB denied trespass, claimed that disputed area is part of the common property. Is the statement of claim pre-declaration that the disputed area is owned by them and claim damages for trespass. JMB counterclaim for the cancellation of the registration as the owner of the disputed area as it is obtained by fraud. After hearing parties' witness and their submission, High Court dismissed the developer's claim and allowed the JMB counterclaim. Okay. Developer terminated the service of the existing solicitor because they felt that their previous solicitor were negligent in managing the trial by failing to argue in an important issue that JMB has no local standard to challenge indefeasibility of their strata title. Local standard was not pleaded in the statement of claim. Now, how are you going about it's just to challenge and stop the registration from being cancelled pending the challenge. Okay. Before I go into this question, let me see the question from the chat group. Procedure Oh, Order 15, Rule 6 is the intervener proceeding. Mode of application is Order 32, Rule 1. Your notice of application supported by affidavit. Is that okay? Okay, so we come to part A. Developer wishes to challenge the decision of the High Court, stop their registration as the owner from being cancelled. Okay, how are we going about to this question? Correct. Obtain a stay of execution. Keyword is here. Wishes to challenge the decision pending the challenge. You see, pending, this is very important. So that your answer is purely based on the stay of execution. Because why is it allocated for 15 marks? Because the first thing is you have to describe what is a stay of execution. And now pending your appeal to the Court of Appeal, you have to quote the correct section in your answer by telling pursuant to which particular section, this is the section for the stay of execution. After you have generally described the stay of execution, you have to also list out the items included in the stay of execution. Serangoon Garden, Leong Po Chi, Dr. Sri Lim Leong Sik for the nugatory principle, and then the Vincent Tan's case. That is how are we going to answer your 15 marks question. Okay? Now we come to part B. Developer wishes to know how the local standard issue can be raised when challenging the decision of the High Court and the likely chances of being able to raise. Okay, why? Why they say JMB has no local standard? Okay, so for part B, right? Any ideas? Actually, looking at the question is quite difficult, right? But the answer, I scared I might be simplified lah. Because you see, keyword is here already. The local standard issue was not pleaded in the statement of claim. So now it is purely based on fresh evidence in an appeal. Your Ladd and Marshall case comes out again. For the case raised by Cindy, um, maybe your answer is correct because I didn't study for this case, but based on the keyword in the question, the issue of local standby was not pleaded in the statement of claim in the for the by the developer. So that this question is asking you whether this can be raised in an appeal. Of course, yes. Yolette and Marshall principle not available during the trial suffice. Then chances of influencing the decision fulfilled, and then credible, obvious. This is how are you going about going to answer your 10 marks question. And you also have to quote the relevant section as well to suffice your 10 marks. Is that okay? Okay. Number four. Lim is selling his car to Wong when it was destroyed by fire. Wong paid the full purchase price to Lim. The fire insurance of Lim cover on the car was still in force at the time of the fire. Now, Lim made a claim for insured value of the car from the insurance company. Meanwhile, Wong informed the insurance company to pay the insured sum to him as he became the beneficial owner of the car. Insurance company is now facing competing claims from Lim and Wong and seek your advice. What is the procedure should be taken by insurance company? Any idea? Keyword is there already. Yes, interpleader. What kind of interpleader? Bear in mind, we have we have two kinds of interpleader. One is stakeholder, one is sheriff interpleader. So based on the fact that now the insurance company is facing a competing claim between Lim and Wong. So it is a stakeholder interpleader. And your case is uh Teton Salina and Cohen taking there, if I'm not mistaken. So by including this case in your answer, you also have to include the order 17. Is that okay? Okay, part B. The landlord filed rate action against the tenant XYZ. And against the director of XYZ as guarantor in respect of the tenancy agreement, claim against XYZ is 50,000 being arrears of rental, general damages unauthorized, blah blah blah. Claim against the guarantor is for arrears of rental only. Solicitor of XYZ and the guarantor filed memorandum of appearance but failed to file a defense, although landlord solicitor had given notice of intention to enter default judgment against defendants on account of their failure to file a defense. Advise the landlord on the procedure to enter default judgment against the defendants. Anyone? Yes, it is a default of defense because now we can see that the defendant forgotten to serve them another statement of defense lah. So this is the so-called default in defense under Order 19. Okay, we move to part C. Plaintiff filed the writ action claiming damages in defendant against the defendant for breach of contract. Sessions Court granted judgment in favor of the plaintiff. Being dissatisfied, uh, the plaintiff filed a notice of appeal to the High Court confined only to issue of damages. The defendant, upon receiving recourse of appeal, filed a notice of cross appeal appealing the whole decision. The plaintiff recently discovered some documents he wants to rely on during the hearing of the appeal to try to persuade the High Court to increase the quantum of damages. The plaintiff has sought your advice on the following issue. First thing, whether he can adduce fresh evidence during the hearing of appeal in the High Court. Quite straightforward, right? Yes, you're still going under your Order 55, Rule 7, and the Ladd and Marshall case. So first one is already covered. Now the second one, whether he has any ground to object the notice of cross appeal filed by the defendant. This one I think I've covered quite recently. Yes, it's on notice of cross appeal. The notice of cross appeal, right? You can only confine to the issue, to a certain issue or partial issue only. You are not allowed to against the whole decision of the court. So that by quoting Order 55, Rule 8, this is your answer already. Is that okay? Okay, number 5. Abu, one of the shareholder and director of BOOM company, took a loan from bank. As director, became one of the guarantor for the repayment of the loan by company together with other directors. Abu subsequently sold his shares in the company to Malek and resigned as a director. One of the terms of their share sale is that Malek undertakes to request the bank to accept Malek as a guarantor to replace Abu, and Malek will indemnify Abu for any liability arising from the guarantee. Upon completion, Malek became director, but bank did not agree to accept Malek as the guarantor. Abu remained as the guarantor for the repayment of loan. 7 years after share sale completed, company defaulted in the repayment of the loan, and the bank sued both the company and the guarantors, including Abu. Malek was not sued. Upon being served with writ and statement of claim, Abu entered appearance and filed and served the defense. How can Abu seek indemnity from Malek in the legal action commenced against by the bank? I don't see why it's Order 15 Rule 6 lah. But I guess but I would say third party proceeding is more relevant. Order 16 is enough already. Because when you are using when you are using the when you are using the what when you are using the non-joinder, you cannot use the third party proceeding already. So that the best thing is you bring a TPP against the third party proceeding TPP against Malek. Okay. Now the second part is whether Abu can apply to the court to order Malik to pay directly to bank any amount which he may found liable to pay to the bank. This one, right, was never asked in the previous papers, so that you may refer to Order 16 Rule 4. Because in Order 16 Rule 4, right, this is the third party direction, so that during the third party direction, the court will give the direction as to ordering what should the parties do, so that unlikely Abu can ask the ask Malik to pay directly to the bank lah. It's up to the court's direction whether Malik has to pay. Is that okay? Okay. Whether limitation period set in for the indemnity claim against Malik. To answer this right, you see, 7 years after the completion, 7 years after the completion of the sale of shares, then the company defaulted in the repayment. So pursuant to your section 6, right? The tortious claim is 6 years. So that if you want to, so your breach of contract is 6 years. But now being served being served so that it's still within the 6 years or not? Any idea? Oh, sorry. Has the limitation set in for the indemnity claim against Malek? Obviously no lah, because now he's starting so that it's still within. So that is asking you how long, what is the limitation period for Abu to bring an action against Malek? So 6 years is correct. Okay, thank you, Sandy, for your reminding. Okay, we go to part B. Plaintiff obtained the final judgment against defendant for the sum of 50,000 in June 2016. Plaintiff unable to enforce the judgment as defendant went into hiding. Sometime in July 2022, plaintiff managed to discover whereabouts of the defendant, who now rents a shop unit to operate a mini market. So advise the plaintiff the procedure to be adopted to enforce the judgment. I guess this one you all might know how to structure your answer already, right? Can you all share in the group chat? Okay, Keyword is here, procedure to be adopted to enforce the judgment. So your answer should be including limitation period. So according to your section 6 sub 3 of your Limitation Act, 12 years from the date of judgment. So looking into the timeline, 2016 is still within the time. However, he wants to enforce it in July 2022. Well, this question, the marker is quite lenient already. Some more giving you a very clear timeline after the expiry of 6 years. So according to your Order 46, Rule 2, you have to apply for the leave of court to enforce the judgment, and no interest is entitled to be claimed. So when you cited these two orders, one order 46 and your section 6 sub 3 of your Limitation Act, your answer is almost there already. Is that okay? If you want to add on, you can add on the method of application is by the ex parte notice of application supported by affidavit under your Order 46 Rule 3, if I'm not mistaken. Is that okay? Okay, now come to question number 6. Beneficiary under trust file writ action against the trustee alleging breach of trust. Trustee, upon reading statement of claim, took the view that allegation in respect of the breach are too brief and also vague. Advised the trustee on the procedural steps to obtain more details of the allegation and the principle adopted by the court deciding the issue. Any idea? Keyword is there already. Yes, further and better particular, Order 18, Rule 12. So, in your answer, right, you have to include one case, Lim Ki Tiak. Your particulars to be sought is within the fact arises. And then how are you going to apply? 32 Rule 1 again. And also, you can also use a formal letter lah if the question is not sufficiently answered, or the other side has opposed or ignore your request lah, then you can file notice of application supported by affidavit under Order 32 Rule 1 lah. Okay. B. Plaintiff filed writ action against the defendant for selling a printing machine which was defective after pleading close on the first case management day. Parties ordered to exchange their document for inclusion, bundle of document. Upon being served, realized that defendant had not included an important document containing the warranties in respect of the printing machine, requested the defendant to furnish the document, but defendant refused to do so. Plaintiff does not have a copy. Okay. How to compel the defendant to produce the document? What is the procedure? I guess this one is quite simple, right? Yes, Order 24, Rule 7, discovery of document. Okay. Now we come to C. Plaintiff and defendant recorded consent judgment to settle dispute. After consent judgment sealed by the court, defendant made an application to set aside consent judgment on the ground that he was misled. Now, the plaintiff, on the other hand, discovered that it was an accidental typo error in the consent judgment. Instead of 50,000, it should be 55,000. Answer the following. Whether defendant's application to the court is procedurally correct. Well, this one is not what usually asked to set aside a consent judgment. Any idea? To set aside the consent judgment law. Yes, consent judgment is like it's like a contract. So that when you are going to set aside a consent judgment, right, your contract rules applies. Mistake, misrep, fraud. So this is the case. Lau Ming Hing. So by quoting this case, and when you explain the principle of a consent judgment and how to set aside, first part is covered already. Now, whether the second part is whether the plaintiff may apply to the court to amend the error. Of course, can lah. Order 20 and 11. Typo error or slip rule. 7. Plaintiff filed writ action for defamation against 3 defendants. Okay. After he served the writ on first defendant before the first defendant filed defense, what a lengthy sentence. The plaintiff discovered that first defendant was sued in the wrong capacity and to amend the capacity of the first defendant. Okay. Second, after service to the second defendant, the plaintiff discovered omitted certain relevant facts and he wants to amend the statement of claim by adding certain relevant facts lah. Okay. Now the third defendant is he wants to amend because the third defendant had died. Okay, he wants to bring the action against the deceased, the estate of the deceased for third defendant. Okay, advise the plaintiff whether the proposed amendment will be allowed by the court. Okay, we answer the questions one by one now. When you see this kind of question involves multiple parties, right? So the first defendant is he wants to alter the capacity of the defendant, whether this is allowed. Anybody? Anybody who says yes means during my during the previous session of the amendment you all might have missed out this question. You may flip to your Order 20 Rule 5 Sub 4. The party is only allowed to alter the capacity for himself, which means that the plaintiff is only allowed to alter the capacity for the plaintiff side, not the defendant side. Bear in mind, luckily, this is now we are still doing the past year question. If real question, tap out already. Okay, remember, second, he wants to include the certain relevant facts in the statement of claim, whether this is allowed. Anyone? 20 rule 3. Let me flip again. Not order 20 rule 3, but order 20 rule 5 sub 5. You want to you want to include the cause of action arising out from the same fact. Order 20 rule 5 sub 5 is sufficient already. No need to go for 20 rule 3. Okay? Now, third part, defendant died already. He wants to amend by bringing by amending the pleadings by bringing another by replacing another one. Is that possible? No. I saw the answer no. Why? Correct. When you're looking into your Limitation Act, Section 8, the survival of cause of action will not apply to certain case like adultery, defamation. So Sandeep, your answer is correct. In the case of defamation, right? Once the party has died, you cannot sue. The cause of action will not survive. That's why I say this paper is quite challenging and tricky. So everyone has to be aware before before you are going to put your answer yes or no. Look into the first look into the fact correctly. Action is thought of defamation. So pursuant to your Section 8 of your Limitation Act, the cause of action will not survive upon the party's death. Is that okay? Okay, Sandeep, for your 7A, so I believe that second and third you have already covered, but now I guess you just missed out for the first defendant, right? Okay, for the first defendant, uh, I already covered in in the previous session where Order 20 Rule 5 Sub 4 is only applicable where the party is amending the capacity for his own side, which means for the plaintiff, if he wants to alter the capacity, he is only allowed to do so if the capacity is on the plaintiff side. So that means plaintiff amend the capacity for the plaintiffs and the defendant amends alter the capacity of the defendant. You cannot alter the capacity of the other side. Is that okay? Okay, we come to part B. Defendant's counsel, due to oversight, failed to attend the PTCM of a civil suit heard by the judge. Counsel for the plaintiff present. Due to absence of the defendant's counsel, judge struck out the statement of defense and entered judgment for the plaintiff. Advised the defendant on the procedural steps he should adopt to set aside the judgment. How to go about? Yes, pre-trial case management is correct. So your answer is wholly based on Order 34, sorry. Order 34, the relevant one will be Rule 2, Rule 3, Rule 6. Is that okay? Since 8 marks question, you just need to find uh you just need to find the relevant one and then you copy bullet also secure. Because the thing is, in the pre-trial case management, there is nothing, not that much cases for you to support. So that even though you are simply copying the rules of court, it's also okay for those topic with a very less cases lah. Is that okay for everyone? Before I move to the last question for today, let me flip again, Cindy, for the answer. Rule 2 sub 4. Yes, because if you are under panic and due to the constraint of time, you just need to copy the 32, 34 rule 2, 4, and 6 lah. You are not necessarily to copy everything under rule 2 lah, because I can see rule 2 actually is quite lengthy as well. Okay? You just need to find the keywords and apply into your answer. That will be enough. Because okay, I saw another question. When we are going to use rule 1, then we will use rule 2. Yes, Order 34, Rule 1 is for you to give an idea for your answer. So that since the fact concerning the absence of the party, you have to tell them what are the consequences, and then you then only can explain what is going to happen. Is that okay? Okay, now we come to the last question. ABC ABC Bank commence order for sale proceeding against the borrower, default of payment. Bank served the originating process and affidavit to the borrower. The borrower did not attend to the court on the first hearing day due to unforeseen reason. Matter was adjourned is now fixed for hearing on the date at the end of next month. Advise the bank on the mandatory requirements which are to be stated in the affidavit and the additional procedural requirements to be complied with before the next hearing date. Any idea? Okay. Any more? All right. Just one case, Lamchun Realty. The reason why I quote this case is the court held that Order 83, Rule 3 must be complied with strictly. After you included everything, you can write a small little conclusion, explain to the at the bottom by telling that these are the procedural steps that the bank has to comply with. Is that okay? Okay, let me stop recording first.